The next speaker is, what I can call, in this session, a guardian angel, because after, this catastrophe, which were shown in the previous slides, I think that we all need somebody, pay for it, and then, who is better than John Croucher, the head of division of the offshore division at the Standard P&I Club. The Standard is basically the largest club in the European shipping community, and equally is the largest club in the offshore because they cover both E&I and Saipem. So in Italy, I would say they have a sort of dominant position in this field as well. And John is qualified as solicitor in 2008 at the Supreme Court of England and Wales. And I leave the floor to him for his speech, which is basically, P&I cover for offshore operations.
Right, thank you very much. I'm not sure I have ever been called a guardian angel before, but I will take it. So as seen by the title, I'm going to talk, hopefully within about 10 or 15 minutes or so, about the nature and extent of P&I cover that's available for offshore operations, and where we would need to provide extensions to the usual mutual poolable cover that most ship owners would enjoy. I think it's probably important to start off by saying, in the context of P&I, what do we mean by, by offshore? The operations I'm going to talk about are not traditional contracts of carriage from cargo of people from A to B. They tend to be more contracts for services. And those contracts tend to directly or indirectly be involved with oil and gas exploration, production, or construction. And as we've seen from Richard's presentation just now, that can lead to some very high and potentially disproportionate risks. If you're looking at perhaps the difference between the day rates that a supply boat might be on against the asset values of the property that they're supporting and the consequential losses, then it can be quite difficult. And as a result of those risks, there's either no access to or limited access to poolable P&I cover because of either the nature of the contract, the operation they're performing, or the type of ship. I'm not going to go into all the details of mutual P&I cover. I'm going to take that as read. I'm going to assume that people understand the heads of cover that the P&I clubs talk about, but I'm going to talk about mutual and non-poolable P&I quite regularly. Suffice to say that mutual cover is for mutual risks, and that is set out and defined by the pooling agreement. So non-poolable risks fall into three basic categories, either by the way you contract, the type of activity that you're performing, or the type of ship that is carrying out the work. I'm going to look at each in turn, starting with contracting. There is a basic premise within the pooling agreement, and that says do not contract for liabilities you wouldn't have otherwise have had at law. So you can either contract on at-law terms or alternatively conclude a knock-for-knock agreement. There are some specific types of contracts that have bespoke terms under the pooling agreement. And again, I'm going to look very, very briefly on a high level for each. Starting first with heavy lift carriage. So whilst there still remains poolable cover in respect of cargo carried on a semi-submersible ship or any other ship exclusively designed for heavy lift carriage, there are some provisions. And that says you must contract on heavy con terms. So you've got to have an indemnity in respect of loss of, damage to, or wreck removal of the heavy lift cargo. And to the extent our members are not able to achieve that, we can provide them with a contractual extension to a fixed limit and fixed premium for the additional liabilities that they're incurring under the contract. We do think that it is important, however, to consider which market is the most appropriate. If you have a contract whereby the heavy lift operator is assuming all liability, irrespective of fault, for the heavy lift cargo, and they waive their right to limit it starts to look like a transference of the first-party property risk as opposed to a third-party liability. And there's a specific market in Lloyd's that can deal with that, as opposed to transferring it as a non-poolable P&I risk. Towage, I'm only going to address towage by an entered ship. There is different provisions in the group relating to towage of your ship if it is being towed. But again, in order to enjoy full mutual poolable P&I cover, and to the limits that means, you must contract so as to have no liability for loss of, damage to, or wreck removal of the tow, unless you're acting so as to save life or property at sea. And the usual standard BIMCO form contracts will achieve that, whether that's tow con, tow hire, or even supply time. But it's important to make sure the ownership of the tow falls within the group from whom you're getting an indemnity. Looking now to types of operation. I'm not going to try and address everything that is touched on in the pooling agreement. There's certain things like ROV operations, divers that I won't address. And I'm going to concentrate on what is defined as specialist operations. There's an extract from the definition of our rules, but it's reflective of what is in the pooling agreement, which is a non-exhaustive definition. But basically, it's any activity which is involved with construction, installation, or any penetration of the seabed. So if you are carrying out some of these operations, what exactly does that mean for cover? It is not a complete exclusion. You will still have poolable cover for 3 heads of claim. Firstly, personal injury of anyone on board the ship, wreck removal of the entered ship itself, and oil pollution from the entered ship. So the slide there actually only mentions pollution, but it's only oil pollution from the ship which remains poolable. Any other third-party liabilities that arise as a result are ordinarily excluded, where they arise during the course of performing specialist operations and as a consequence of the specialist nature of it. So it's quite a limited exclusion. So for example, if you had a cable layer that was navigating to the field and it had an incident, that would remain perfectly mutual and poolable and would be shared by the group. However, once it had got to site, perhaps taken an act preparatory to starting to lay cable, such as switching over to DP mode, then those other third-party liabilities would need an extension to cover again to a fixed limit and against a fixed additional premium that would be charged. That is not a blanket extension. We would still exclude failure to perform. So if, for example, you lay the cable in the wrong place, we wouldn't pick up the cost of going back and relaying the cable. Or fitness for purpose, so if a module is picked up and installed on a platform, but the module has a defective part, again, the costs involved in fitting out that defective part would not be covered by the club. And also, we'd exclude loss of or damage to what is described as the contract works, so the subject of the contract. Again, in the case of say a pipe layer, it would be loss of or damage to the pipe being laid as opposed to any other existing property that might be in the field. Looking at types of ships, I'm going to concentrate on production and drilling risks. They're treated slightly differently by the group. So I'm going to look first at drilling. And as Richard briefly mentioned, post the Perro Negro 6, there was a slight but a significant amendment to the pooling agreement. And that basically says that any ship constructed, adapted, or designed for the purposes of carrying out drilling operations in connection with oil and gas exploration are excluded absolutely. So even if they're laid up or under conversion or upgrade, there's no access to poolable cover at all. And at the Standard Club, we'd provide a bespoke, non-poolable cover on terms that are designed for drilling operations to step in and provide the same heads of cover that poolable mutual P&I cover would ordinarily provide. Production is slightly different. Again, I've set out the whole exclusion in respect to production operations on the slide. The important point to note is where it says arising out of or during production operations. So that is where an FPSO, for example, is navigating to the field or is perhaps not yet at first oil, then she would technically be able to enjoy poolable mutual P&I cover and to the very large limits that provides. So there is potential poolable cover there. However, we would deem production operations to have commenced from the point of entry to the field, and then the bespoke non-poolable fixed premium terms would be required. It's probably also worth noting that in respect of storage units, so FSOs, for example, where they're directly connected to a well, or there's oil and gas separation equipment on board, and oil is actually being separated from gas other than by natural venting, then they're deemed to be within the scope of the production exclusion. So normally an FSO would be poolable, but depending on the configuration, we might need to look at it slightly more closely. Where we do provide an extension for these units, it is a named P&I risk only, and there are bespoke exclusions which would include the well-type liabilities, which we typically expect the field operator to pick up. So the control of well-type cost, and those liabilities arising from blowout. Final type of ship, accommodation units. There's two provisions of the pooling agreement that need to be considered for these accommodation units. The first is linked in actually with the contracting style. You can have mutual cover for accommodation units, provided you contract so as to have an indemnity in respect of the accommodees on board. Effectively, the non-marine personnel must be off-laid to the charterer. However, the extent to which an accommodation unit is deemed to be integral to a drilling or production operation, it might also be excluded completely from international group cover. And it's generally accepted that if a unit is within the bridging span of a platform, or it's permanently moored within a 500-meter zone, then it would be considered to be integral. Although the international group is looking at this exclusion at the moment, so it may be modified. So finally, to really just sum up, what are the solutions to this? Well, we would always seek to mutualize cover wherever possible. We think it's the most effective way in order to provide the widest cover at the cheapest cost. Now, where there are some limitations on access to that mutual cover, we would then supplement it and give extended covers, whether that's contractual, specialist operations, the use of ROVs or divers, or some of the bespoke salvors extensions that we can provide. And when there's no access to poolable cover at all, we do have a set of rules to reinstate cover to the highest limits available in the market. We can provide up to $1 billion for production or 500 for drilling, all with a rated security or higher, in the same mutual P&I club service. Thank you.
Thank you, John. A very wide overview of the P&I cover in all, if you like, segments of the offshore industry.